I'm a LexDAO member and in charge of the study group. This is the second one about MICA. The first one with where there were also Marina and Vyara from EUCI. It was about the legal treatment of tokens in MICA, and now we are going to speak about CASP, crypto asset service providers. It's probably the hottest topic in MICA. I would like to thank you, everyone, and this is something that as LexDAO we would like to offer for the common goods of the crypto space. So I would start with Vyara, and if you could please give us a very brief description of what is a CASP, crypto asset service provider, or VASP, virtual asset service provider, before MICA. In the EU and especially in the under the Financial Action Task Force notion, because probably the first one, which, if I'm not wrong, is been introduced in 2018, so much before the many countries were thinking about crypto. And why? What is the logic? Just the overall logic of Title 5 of MICA, which is the title about CASP. Thank you very much.
Thank you, Paolo, and thank you for having us again. Yes, I'm Vyara. I'm part of the European Crypto Initiative. Here with Marina, we are part of this advocacy organization that works on Brussels level, explains how regulations should be shaped up. So when it comes to crypto asset service providers and how we got here, we obviously need to start from the concept of virtual asset service providers, the so-called VASPs. So that's a term that existed before MICA. So in a sense, what MICA does is it expands and adds on top of the concept of virtual asset service providers. And the virtual asset service providers itself comes from guidelines from the Financial Action Task Force from 2019, which is a guideline on virtual assets, where we have a definition of what a virtual asset is. It's quite different from what MICA has in mind, because it's, at the very least, it doesn't mention DLT. So it's, in a sense, broader because it's not so limited by the technology that's at the heart of the asset. And it's another very specific aspect of this virtual asset service provider concept is that it's mostly for the purposes of anti-money laundering and countering financing of terrorism, because the Financial Action Task Force is it's a global organization that focuses on this type of framework. So it tries to unify, to a certain extent, the concepts of money laundering and the anti-money laundering specifics that are adopted by its members. So that was also done by the European Union. So the virtual asset service provider was already kind of integrated into the anti-money laundering directive, the fifth one. So we had this concept before we had CASPs. However, that was not enough because A, it was only for AML purposes, and B, it wasn't that tailored when it comes to what we understand as crypto assets. So then what was shaped by the European Commission and then adopted on an EU level, the Marketing Crypto Assets Regulation has this much better and much broader definition of what a crypto asset is, what a crypto asset service is, and therefore what a crypto asset service provider is. So we have Chapter 5 of MICA, where we have all the rules that affect and are related to the provision of crypto asset services in the EU. So I'm not sure how much Jonathan will go into all the details about Chapter 5, so I will not steal from his topic, and will only say that the most important parts in that part of MICA are the authorization requirements, the requirements around what are the responsibility of CASPs, such as reserves and prudential requirements, as well as the very, very important concept of consumer protection and how MICA protects all of us as crypto asset service users, consumers, in a way from what the market can sometimes be. Basically turning it more into a more traditional financial market rather than unregulated space for transactions. So that's one very big difference. Virtual asset service providers, mostly for AML purposes, crypto asset service providers, a concept that is currently applicable only in the EU to regulate the general and broader crypto asset issuance and crypto asset services market in the EU. So hopefully it would also unify the market and also has an overlap. I don't know if that would be interesting. Maybe we can expand it in the questions, but also an overlap with the travel rule that is currently being adopted with the transfer funds regulation. So now basically in the EU, we have I would say, a much clearer idea of what a crypto asset is and what are the services one can provide with crypto assets and what are the rules applicable to this type of services.
Okay. Thank you very much for this very interesting description. So Jonathan, now please, can you give us a description of the legal discipline of CASPs in MICA? I mean, most relevant rules, lights, and shadows. Maybe there are shadows. Yeah, thank you.
I was happy to elaborate more on the shadows, but let's start with the clear parts first. So as Vyara rightly mentioned, Title 5 of MICA, and I would say one of the main purposes of MICA really and truly, is to assimilate as much as possible crypto as service providers to traditional financial institutions and the way they are regulated within the EU. In fact, one can immediately notice that there are certain elements of familiarity between MiFID II and MICA itself, especially since there's also a level of equivalence in terms of certain crypto asset services and certain financial services as well. So some of the main, I would say, points relevant for CASPs under MICA is that first and foremost, one needs to be authorized as a CASP in order to be considered as a CASP under MICA. It's part and parcel of the definition of a CASP under MICA, and therefore, if one is not authorized to be a CASP, then one cannot call themselves a CASP. This might seem like a minor point, but it's very much a relevant point, especially when talking about the grandfathering period of services providers, because there is a bit of, I would say, uncertainty on what the grandfathering period really means. In essence, if one is nationally regulated as a service provider, they are not a CASP. They are only a CASP, even if they are availing of the grandfathering period, they will only be a CASP once they are authorized or licensed actually under MICA as a CASP. What does being a CASP actually entail? There are prudential requirements as opposed to, let's say, a simple registration under the 5th AML directive as a VASP, rather, which is how most EU member states have been regulating services providers up until now. The minimal prudential requirements vary, I believe, from 50,000 to 150,000 euro, depending on the services being offered. Or in lieu of the minimum funds requirement, one can also take out insurance, the required insurance policy in terms of professional indemnity and any other aspects which can be covered by insurance rather than having a minimum own funds requirement, which I tend to find quite interesting. There are also governance arrangements which need to be in place, and also, I would say, any members of the management body need to be fit and proper, and I would say scrutinized by the competent authority, by national competent authority, to see that they can actually manage and lead an entity that is, for all intents and purposes, licensed under European law. We've thought about reserves or the safekeeping of client funds. I would say one of the cornerstones of MICA And I don't think I need to enter into any past famous incidents where there was the commingling of client funds or the mismanagement of client funds. And the European legislator made it amply clear that this is something that needs to be protected at all times in terms of the ownership rights that the users have, the clients have over their own funds when being safe kept by the CASP in question. There's a lot of focus, as Vyara said, on I would say, the concept of consumer protection. So in fact, for instance, there's a lot of focus on complaints handling procedures. Quite surprising, in fact, even to see the level of detail that is included in the RTSs in terms of how complaint procedures should be handled, which shows, of course, that one of the predominant, I would say, criteria for the legislator was indeed consumer protection. There also needs to be the disclosure of conflicts of interest by the CASP, and although it's a different and separate title, I would say the consequent title, which is Title 6 on market abuse, ultimately links a lot of these different aspects together, because ultimately the market abuse title is mostly targeted towards CASPs, I would say, which not only need to ensure that market abuse is not happening, but also need to have the required systems in place to prevent, detect, and report market abuse, all in the name of preserving market integrity, and also, of course, the interests of their clients. What about the gray areas? Well, contrary to some other legislative instruments that I've come across, the concept of admission to trading is a bit of a curious one under MICA. Why is that? Because the concept of admission to trading only applies to trading platforms. And there is still a big question mark on what about any of the other CASPs, which are not offering the operation of a trading platform as a service, but of course they are still, to use the general term, listing crypto assets or providing services in relation to crypto assets, such as OTC desks, which would not necessarily require a license as a trading platform. So this is quite an important concept because, first of all, it places a whole host of specific obligations on CASPs operating trading platforms, as opposed to other forms of CASPs. And this has led to, I would say, up until a few weeks ago, and I'll say why, a lot of CASPs, or I would say prospective CASPs, saying it's not worth getting an authorization as a CASP operating a trading platform. Let's just go for dealer broker model and then ultimately route our orders or transactions to other entities outside of the EU. Typically, what we tend to see in dealer broker models under MiFID. ESMA issued an opinion saying, nope, you can't do that. We will not allow it, or rather, our opinion is that this will not be allowed, and it seems to indicate that they were aware of this particular, let's say, trend in the market, and they want to put a stop to it. There had been criticism of ESMA's opinion on this because it seemed to target specifically the routing of orders within the group, and seems to indicate that the routing of orders for execution within the same group is not allowed. However, that would go against MICA itself, because if the best venue for execution of a particular order is an intra-group company, nothing under MICA, not even ESMA, can put a stop to it, because that would actually be in breach of MICA itself. That's one of the gray areas. The other gray area, once again relating to digital trading, is what about the addition to trading on a trading platform's own initiative of EMTs and ARTs. This is not regulated under MICA. This is not specifically catered for under MICA, because MICA speaks specifically of two specific acts when it comes to stablecoins: the offer to the public of ARTs and EMTs, which I will call as stablecoins, and seeking and digital trading of ARTs and EMTs. The concept of seeking and digital trading specifically relates to any person apart from a trading platform going to that same trading platform and saying, Mr. or Miss Trading Platform, can you please list my ART or EMT? That requires authorization under MICA. However, if a trading platform seeks to admit to trading on its own initiative or self-listing an ART or EMT, that is nowhere to be mentioned under either Titles 3, Titles 4, or even Title 5. And that is a bit of a gray area, because the law does not mention it. Now, in my mind as a lawyer, if a law does not mention something, the law allows it. Simple as. This is a centuries-old principle, harking back to Roman law, I would say, where if the law does not mention something, then in view of its silence, the law allows it. But it seems there is quite a significant ongoing public discourse at the moment. I think also ESMA and DBA have caught wind of this particular point, where worryingly, perhaps Marina or Vyara can shed some further light on this, worryingly, it seems that the EBA and ESMA might be inclined to even perhaps state a public position that only issuers who are authorized under MICA can apply for trading of ARTs or AMTs, which, frankly speaking, would be preposterous. It would have no basis on the law itself. Plus, it would, frankly speaking, exclude most of the major ARTs and AMTs out there, including the likes of Staked ETH, USDS, USDT, Wrapped Bitcoin, Wrapped ETH. The list goes on and on. So, as usual, a bit of an incendiary commentary from my end, but I hope I made things a bit interesting.
Yeah, thank you. Thank you very much. It was very interesting. So first of all, let me thank Dr. Lau, who is here. Lawrence Lau is a long-time member of LexDAO, so we are very happy to have it here, Lawrence. So, okay, that said, I will, Marina, please take the floor and give us an idea of what's the political behind the curtains of CASP in MICA. I mean, you followed from a EUCI perspective. Which was the political compromise between CASP in the secrets of the European Parliament, let's say.
Hi, thank you, Paolo, again for organizing this, and thank you also for the questions. So what is interesting here is, I know we discussed this many times, and we mentioned that it seems that the most important topic when it comes to MICA was really the stable coins, and that was kind of, started with kind of a Libra at the time, a quick reaction to what Libra might be in the future in order to prevent, or at least to think about the sustainability of the financial system in the EU. And that was, I would say, the most important part when we talk about MICA from the beginnings. Of course, the other part, when we think about another goal coming from MICA, is the consumer protection. And that's where we're thinking about CASPs. We're thinking about specifically, I would say, there are a few definitions of CASP. I know that we discussed that from the beginning, mostly custody and administration of crypto assets, operating and trading a platform. And here, especially in the second one, I think those are really the crypto asset service providers that most of the users use at the moment, the crypto, in a way, users. And this is where we have seen not really good examples in the past. I would say that maybe the reason why we don't have regulation might not be the number one reason why these things happen, but it's really something that could happen when any, I would say, centralized entities. But anyway, the regulator was really focusing on the consumer protection here and thinking about how can we ensure that those services are going to be, in a way, following these principles. Beyond those two custodials, we have also exchanging crypto assets for fiat currency or other crypto assets, executing orders for crypto assets, and providing advice on crypto asset. So those are, as we have defined, few service providers. They're very, in a way, I think, pretty clearly understandable through to who needs to be regulated under MICA, except from different ones that might be decentralized. And this is where the interesting part comes in, especially when we were discussing during the negotiation processes, where we were thinking about all the use cases and all the things that are happening in this ecosystem, especially for DeFi. So during the negotiations, we went through the DeFi summer, and DeFi was very important at the time, of course. And the regulators were still learning about that. And what the discussion went at the time was, what should we do with DeFi? There were different proposals, specifically coming, I would say, mostly from the parliament, saying that, DeFi should be included, or that even DAOs should be included in MICA. And after the whole negotiation process, we have obtained an exclusion when it comes to, in a way, this part. And specifically, I would like to state the recital 12A, where MICA states where crypto asset services are provided in a fully decentralized manner without any intermediary, they do not fall within the scope of the regulation. I know we have discussed that many times, but this is a very, very important part that was negotiated due to activities of organizations like EUCI and others. And I would say that we went back because we were applying for some funds for retroactive funding for EUCI. And we did a whole analysis of the discussions, papers, and meetings that we had at that time. It was end of 2021, beginning of 2022. And we have seen that basically us and another person coming from Germany were the only ones, for to our knowledge, asking for DeFi and DAOs to be excluded at the time. So we're pretty proud of that work. We also wrote a few position papers at the time, but it's just to show that without the activities of, industry and policy organizations, those things are not coming by themselves. This kind of activities need to happen, and especially education around that time. So this is where, as Jonathan was stating before, there are a few gray zones. What is outside of the scope of MICA, especially when it comes to CASPs? What is decentralization? To which extent do we define that? What does it mean provide services in a fully decentralized manner, etc.? So this is, I would say, very, very political, and it was political in the past, and right now it's going to be, of course, on the national competent authorities to understand better and to fulfill these definitions. I know that Jonathan has, written a lot about that. I don't know if we want to go into that direction as well. We have written position papers, but it is really one of the most interesting and fascinating topics that we think about within MICA, especially when it comes to crypto asset service providers. So this is one part that was pretty interesting. And another part is when it comes to basically MICA and the reasoning why we have MICA and why we have a definition of crypto asset and crypto asset service providers, and how it connects to the existing financial regulation and how it connects to the existing financial services providers and institutions. And this is the part where basically, if you are a financial services provider that you already have certain licenses, it is easier for you to basically obtain or basically start offering services that are regulated within MICA. So there's no need for authorization. There's only a notification requirement. So 40 working days before offering these services, such services, you need to notify this authority. So that's also, I think, pretty important when it comes to kind of, relationship to how does MICA interact with existing traditional finance. And I know we had a lot of discussions at the time of negotiations, because the idea is really, who does MICA serve? Do we want to have a regulation that brings more clarity and also, includes smaller companies, SMEs, and startups that are just starting and innovating? And is there a principle, of basically proportionality that we can think about? And here also incumbents and big companies that are already regulated in a different way, and thus, because they do have other licenses, thinking about an easier way to basically offer similar services, again, looking into from the perspective of the consumer protection. So I would say that we maybe just as a conclusion to what consequences might this bring, it's we will discuss that, I'm sure, also going forward, but there is really this risk and worry that smaller companies that will not be able to comply with the whole CASP basically requirements, they might just cease to exist, or there might be some mergers and acquisitions. And I would say that for smaller exchanges, we have seen something similar for the exchanges, and I would say custodials as well in the past, where there was a new law finalized in Germany, and we have seen that few smaller companies let's say wallet providers, the basically custodial wallet providers, and a few smaller exchanges were just not able to follow those requirements.
Thank you. Let me say hello to a couple of friends. Sara and Francesco just joined here. Okay, so thank you for Marina for this very interesting speech about what's happened in the EU Parliament. So now, Dimitar, please, can you give us an idea of what's the situation in Bulgaria? I mean, of course, there is a kind of forum shopping dynamic in Europe where the big countries like Germany, France, Italy, where I come from, possibly are trying to have a more conservative approach, where probably smaller countries, at the very least, everyone thinks it will be easier, probably, or will have a lighter touch in relation to getting a license. So probably, possibly, Bulgaria might be one of them. So please, can you give us an idea of the current situation in Bulgaria? Thank you.
Thank you, Paolo. It's a lot of things were said about gray areas, and this is a gray area in Bulgaria because we still don't have implementing MICA legislation locally. We have a draft law that is currently being debated, and the local community of CASP providers and crypto entrepreneurs, I think, was quite active in voicing their opinions and asking for a more lenient, let's call it, approach. In the draft law, there were probably a couple of things that probably showed, because we don't know how the, that's probably the biggest issue, that we don't know how the regulator, which is the National Financial Commission, will implement MICA and how they will act, and whether they will be more flexible or more rigid. But so far and historically, Bulgaria, I think, has been more on the more flexible side, meaning that before MICA, there has been very little regulation. I think Vyara touched on that only VASPs were regulated only through a simple registration. So historically, I think Bulgaria has been a very comfortable jurisdiction. But there is another thing, that traditional financial institutions and traditional finance has been, a little bit harder to get into in terms of getting licenses and authorizations. And now that CASPs enter on the side of regulated businesses, it is really a big question mark whether the approach will be more heavy-handed or not. And probably that's a little bit of a downer in terms of response, because I want to say Bulgaria is the best place to to register and get a license, but the truth is that this is still to be seen. It is probably a bit telling that Bulgaria, at least that was the proposition in the draft law, that might be changed. But the initial proposition was, for example, that grace periods will be shorter than the maximum amount. So the grace period proposed was the end of 2025 and not June 2026. So 6 months shorter, which probably shows us something. And the requirements, the fit and proper requirements for management were also extended to shareholders in the draft law, which I think is an interesting approach. And it, of course, comes from general AML legislation requirements. So, yeah. But I think, and the way Marina framed it earlier, that bigger players and established players now can comfortably enter the crypto space, and the smaller players, find it more difficult to survive under the new regulatory framework. It is a big question if Bulgaria will turn into the same direction. My feeling and what I've seen from the market is probably that established institutions in Bulgaria aren't that interested into getting into this business. So probably, but it is a lot of speculation how it will turn out. But again, historically, Bulgaria has been a very comfortable place, but there are signs that this might not continue. I cannot say for certain, although I would like to. That's from me on that issue.
Thank you very much. So I don't know if there are comments, questions. Marina wanted to say something. I think she mentioned. Jonathan, maybe, yeah, please.
I would just
and after Dr. Lau, yeah, Jonathan, please.
Of course. I'd just like to point out that although MICA is a maximum harmonization instrument, in that it should theoretically apply across the board in the same way across all EU member states, as we can see from Dimitar's comments over here, the choice of jurisdiction ultimately will be quite important still going forward, despite the homogeneous application of the law. Let's keep in mind that up until now, in the European Union, crypto has been regulated, and again, regulated, I would say the term is to be interpreted in its most generic way possible from an AML perspective only. So there was only the requirement for service providers, specifically those providing exchange services and custody services only, to register with their local competent FIU or equivalent authority for a registration under the 5th AML directive. MICA represents a completely different league altogether from a simple AML registration. We are now talking about a fully fledged license. It's clear that some jurisdictions are still not prepared for MICA, and essentially also the designation of the competent authority may be different than the one designated for AML purposes. So all of a sudden, we have a new authority entering the scene, typically being the National Financial Services Regulator, who in some cases would have absolutely no experience whatsoever in regulating crypto assets. So that's the first point. The second point as well is that this will invariably affect greatly the length of the licensing processes. I will not be surprised that certain national competent authorities will treat this as a training experience and ultimately learn on the job as they go when dealing with certain licensing processes, which again makes the choice of jurisdiction quite important. Moreover, again, getting a license is just, I think, the first and, if I may say, easy step. The difficult part is maintaining that license and operating under, I would say, a fully supervised regulatory regime. So the question is, a rhetorical question, or perhaps an open-ended question, is whether the supervisory authorities are equipped to supervise this industry, which, although it is being treated from a substantive perspective in the same or similar manner as the financial services industry, ultimately we are talking about completely new assets, different ways of doing business, and ultimately there is, I would say, a requirement of at least a certain element of technical understanding in supervising this space. So I just want to highlight those points as well, because there is perhaps the general impression that MICA is set to, let's say, make all of the European Union on an equal footing when it comes to the regulation and supervision of crypto assets. I would venture to say that the next 2 years will be anything but that, and we'll see some divergences, perhaps some very important ones, between certain key jurisdictions.
Thank you very much. So Lawrence, please, your question.
Choice of forum. You all might recall how Bahamas and the US had a bit of a tussle with FTX, and until he was extradited. So supposing we have a Hong Kong company with a registered under MICA type thing, but working on the Chinese BSN. So if a conflict occurs, who takes charge, EU or China?
I don't know if someone wants to answer to this question.
I can take a stab at
Yeah,
that,
please.
but since I just spoke for another few minutes, maybe someone wants to take the lead. Happy to do so myself, but I don't want to hog all the speaking time myself.
I don't know. Anyone?
You can start, but I would like to maybe, if the question could be repeated.
So basically, I think if I understood Lawrence well, and correct me if I'm wrong, Lawrence, but you're talking about, let's say, a company which is both providing services under MICA authorization, but also potentially has some other form of authorization under the laws of China, if I'm not mistaken, and something
Correct.
occurs who, let's say, has jurisdiction over whatever malfeasance there is. Is that correct?
Correct. And you might recall FTX, because they were supposedly headquarters in Bahamas, but the US insisted SBF be extradited to the US.
I mean, the US is a bit of an outlier because the US can exercise and does exercise I would say, the power of extraterritorial jurisdiction, which tends to be something that is quite peculiar to the US. When it comes to the EU, I'll just focus on the EU because, frankly speaking, I'm not very knowledgeable about the laws of China. But what happens in the EU if you're an authorized CASP? First of all, in order to obtain authorization as a CASP, you must have a legal entity set up in one of the EU member states. So you were there, they have physical presence over there, and also the legislation and those national competent authorities insist on there being actual physical presence in that jurisdiction. We're not just talking about one non-executive director or one compliance officer. Actually, the mind and management and control, rather, of the company, part of it needs to be located in the EU member state. So for all intents and purposes, there should be, I would say as an example, at least one executive director who is residing in that EU member state under which they would have a MICA authorization. So there would already be quite a significant nexus to that particular EU member state, and that would also grant, let's say, the power, if you will, to the competent authorities in that jurisdiction to reach out to any individual who is residing over there. And ultimately, if there is, again, any breach of the law, which might result in certain action, then there would be someone who they can reach out to. Action is taken against the company, but still, a representative of the company typically would tend to be within reach of the national competent authorities in charge of, let's say, leading any particular action. Naturally, when it comes to extradition, that's a completely different matter entirely. So extradition is something which is subject to a different set of laws. I mean, I don't think we need to enter into the merits of that since it's outside the scope of today's conversation. If a particular person flees to a jurisdiction where extradition rules tend to be a bit hard to enforce, I mean, then that's a different matter entirely. But to go back to MICA itself, the competent authority, the powers of the competent authorities outlined, if I'm not mistaken, under Title 9 Title 7 of MICA, they are very much dependent on there being certain persons within that jurisdiction, including the legal person having the MICA authorization itself, and ultimately, of course, certain key personnel which would be required to be in that same jurisdiction. Over to you, Marina.
I don't know, Marina, if you have something to do, then we have a question from Anya and another from Dimitar. Marina,
No,
please.
I think you answered perfectly, so let's go on with other questions.
Yeah,
Okay.
my comment, actually, I don't have a question. My comment was just
sorry,
a little bit to add.
Dimitar,
worries.
sorry. We have a question before there was Anya. Anya, please, would you like to pose your question?
Yes, hi there. But I realized that we are only discussing Title 5 here, right? But Lawrence, your question was actually not related to Title 5. If you're asking about stablecoin, I actually just had a discussion 2 days ago about redoing the stablecoin chapter, but I put my hand down because probably it's not the topic here. But basically,
but we can speak. I mean,
yeah, I mean, we just have the EBA issuing their draft standards and talking about Article 58.3 that for non-European currencies, some of the articles apply too. I mean, it's always, as you say, Jonathan, stablecoin issued in Europe. But there is actually an interesting Blockworks article on that, whether it can be enforced, because stablecoin are circulating worldwide, and how to actually track them, because apparently for non-European currencies as well, the cap applies. That is actually put into Article 22. That's a little bit technical here, but I appreciate the question to have a more global outlook, and the difficulty really to basically define the scope of MICA really, and regarding perhaps not the issuance of stablecoin, as you said, Jonathan, being established in the EU and so on, but the transactions will be really a problem apparently, of what I have learned. But thank you.
Thank you, Anya. There was Dimitar. Yeah, please, Dimitar. Sorry.
No worries. Actually, I had raised my hand to add to Jonathan for the question by Lawrence, but nonetheless, I'll drop a question because actually what Jonathan said immediately after the discussion was probably more interesting than what I was going to say now. And the more interesting the thing that Jonathan said was about the preparation and let's call it the know-how that is with regulators, which is usually financial services regulator in most EU countries. And I saw it in Bulgaria, also in the draft legislation. And because this was a very good observation with respect to the fact that probably the first authorization will take more time. And in the draft legislation in Bulgaria, indeed, the deadline for providing a decision was set at 6 months, which is way off the MICA standards. And my first thinking when I saw it was probably they don't know what they're doing and they need the time to, to learn the regulation. And my question to all of you is, in your respective jurisdictions and from what you have seen, whether you have seen this kind of reluctance or probably if you have sensed that the regulators are feeling the pressure of having to learn a new and I think quite heavy regime. So yeah, that's my question. What are your what have you seen on this?
Okay, thank you. So now we have Marina, and I don't know if before Jonathan, Vyara, so before Marina.
No, Vyara was before me. So
okay, so Marina, Vyara, and Jonathan. Okay, thank you. Very gentleman, Jonathan.
Very briefly, so I just literally came from a meeting with a local NCA, and we had a lot of Q&As, a lot of companies coming there discussing what is happening. Dimitar, the question is really interesting, but what's happening is like this, combination of different entities being ready for finalizing the local law that will help implement MICA. So, for example, this NCA has worked on the proposal of the law and sent it to the parliament and to the government, and now the parliament still has not finalized the law, so they cannot continue with the other procedures, like, for example, notifying ESMA that they will use the guidance that ESMA or EBA has provided on certain things, and everyone else would need to follow. So operationally right now as a potential CASP, you don't know if this is really going to happen, but of course those kind of meetings are very, very useful because they at least show and share certain information that are not public yet, and then you have the time to prepare. And what is super important is also this, like, in way period that you mentioned before, when exactly will MICA in a way, be applicable where the license will need to be obtained. To my knowledge, none of the member states have 0 days from the 30th of December 2024 or 1st of January 2025. So there's at least 6 months, which means that, different NCAs will need to require, I don't know, I would say the sooner the better you do apply for a license, of course, but certain have 18 months. So that's a huge difference. There's a whole year in between. And I would say that the deadline for MICA is just a time to take decisions that are very much business decisions, because you will need to look into who and where are your customers coming from and which jurisdictions are important for you, especially with these different deadlines that are different in different member states, even though, in the longer term, you will obtain or you will be in a way passported. So that's pretty interesting. And just another quick comment on what you mentioned before. We don't really have a unified financial market in Europe. There are certain member states that are very strong in financial markets. They do have very strong traditional financial players, and those will be also going to their national competent authorities, maybe asking for opinions when it comes to token issuance. For example, I talked to a few banks that are going to issue their tokens soon, and we know in which part of Europe they are residing. So that's also important to, I think, for the national competent authorities that don't have a very active financial market or even crypto market to kind of be, I would say, operationally ready, that they might not even have a lot of people or companies asking or applying for a license.
Thank you. Vyara?
Yes, I wanted to add now, especially that that Marina answered as well. Basically, for those especially that will be watching the recording, here we are discussing 2 different deadlines. So the one that Marina is mentioning is the deadline that's related to the so-called grandfathering clause. That's Article 60 of MICA, for those of you that like the article numbers also mentioned. So this time frame would allow companies, CASPs, that have a previous authorization under the member state that, as Jonathan said, might be even just this AML registration, just somewhere in front of their, like the authority that supervises their taxation requirements. But for those organizations, there would be this period that is between 6 or 18 months, depending on the member state, where they would still be able to offer their services, but only in that member state. So that's already a bit different, creates a bit of a different playing field. But what Dimitar actually mentioned is, I think, a separate issue, also very, very relevant and very serious. I'm also Bulgarian, so I have read the draft law. I have heavily criticized this specific 6 months deadline that the national authority has proposed for itself, particularly because it also envisions something very common here in Bulgaria, unfortunately, that is a silent refusal of your application. Basically, the authority would have the possibility of just not issuing any response at all, which would be considered to be a refusal, which isn't possible because MICA is still a regulation and we still have those specific requirements when it comes to licensing and what the authority needs to do when there is an application coming from a CASP. So there needs to be this communication. There needs to be type of back and forth. There is a limit in the number of working days within which there must be a response, a written response, argumented response. So it's something, I know that probably Dimitar's question was more fundamental about the preparedness of different member states and their reluctance, in a sense, to adopt those requirements, but still MICA is a regulation, even though we're talking about different application on different member state level. there is still the text of the regulation that would apply at the end of the day, even if the local authorities have some other ideas in mind that would not be sustainable. So yeah, and also I have the opportunity to comment after so many great questions and comments. And Anya, I think another thing that we can also add to the broader confusion is this requirements to determine what the use of the stablecoin is. So I think when it comes to the practical implementation of those requirements, it will be very, very interesting, because who will be reporting? It's, yeah. We're currently responding to EBA's consultation on that. So yeah, quite fresh.
It will be interesting what Theta is doing, right? They have refrained from applying for an e-money license, and would be nice to know the reasons. But so another question, I mean, Marina, you have mentioned banks and financial institutions, and on the other hand, the challenge of smaller exchanges and newbies to actually take the compliance challenge, and also the principle of proportionality. So from a national point of view, the established players have a big advantage in this race, because they just have to notify and have, like, at least from a German perspective, the Kreditwesensgesetz, they have certain privileges in actually this notification process, and actually basically hit the ground running. And in this round, is this kind of a general pattern that these established traditional players have a huge advantage in getting started?
So there was Jonathan. Thanks.
So let me just then go a couple of steps and continue the previous conversation where Dimitar asked about, again, what's happening in I would say our home countries. I have some good news to bear here, because Malta, I would say, was the first EU member state to comprehensively regulate crypto assets, where in 2017, when we were drafting the relevant laws together, we decided to take MiFID as a baseline, strip away anything which might not be applicable to crypto assets, especially how they were back in 2017, and come out with a comprehensive regulatory framework targeting crypto asset issuers, or virtual financial asset issuers, as previously termed under Maltese laws, and also service providers. Back then, I can say that we were criticized for coming out with quite a prescriptive regulatory framework. However, 5-6 years down the line, it turns out that Malta's VFA framework was the most equivalent framework there is out of all national frameworks when it comes to equivalence to MICA. So what this means is that all VFA service providers, now CASPs, or soon to be CASPs rather, under Maltese laws, have already been operating in a MICA-like environment for the past 5 to 6 years, depending on when they were licensed. And in fact, the MFSA has been working hand in hand with all local VFA service providers, preparing them for MICA. So holding interviews with them throughout the course of the year, and ensuring that any minor gaps that there are between the VFA framework and MICA are sorted out before the end of the year. The hope is that the MFSA will start issuing MICA licenses as early as January of next year. I think it's no secret that most jurisdictions want to be the first country to start issuing MICA licenses. The MFSA is aspiring to be one of the first, if not the first, to issue such authorizations. As from the 1st of August onwards, the MFSA has been treating all licensing applications as MICA licensing applications. So already there have been ongoing works for the past couple of months to also start shepherding any new applicants towards the MICA licensing process, also with the view to get them licensed under MICA as soon as possible. Not only that, but we have also crossed some, I would say, troublesome streams with the MFSA when it came to, let's say, discussing certain topics like staking, yielding, or rather yield, and also, for instance, what happens when there's a centralized order book paired with non-custodial wallets, which is a business model that we undertook in a discussion with the MFSA on behalf of one of our clients. So the MFSA is also very technically conversant with crypto assets in general. You can go through them and they will not stare at you with a blank face if you tell them, well, what about the various forms of staking, etc. So at least from a Malta perspective, even though it is the tiniest or the smallest EU member state, a lot has been going on for the past years. And I would venture to say that it's actually one of the best prepared countries for MICA.
Marina? Yeah, please.
Hi, Jonathan, I just have a question for you, or maybe for anyone. Basically, what is the funnel of the projects that are applying to the national competent authorities that you work with? Because I just heard a comment that, you know, basically the ones that were discussing with projects, there was a huge interest initially. And then, you know, by the time passing and their communication needing to be more serious and really, you know, sharing documentation and stuff like that, the number decreased, you know, dramatically. So I think there's maybe some uncertainties, maybe they're not ready yet. You know, we discussed many times, many CASPs have not started even yet. They don't know in a way where to start, or they don't have the capacity, I don't know, or they're waiting for the last minute. But it seems that when it comes to the real applications, there might not be that many CASPs as we think at the beginning.
We've been through this path of pain already from our end. Back in 2018, when we had 300 prospective applicants, back when there was the whole furore of the blockchain island, to which I never personally agreed. And then, when push came to shove, at the end of the grandfathering period, back then, there were less than 30 applicants. Why? Because as soon as they realized what are the requirements in order to become a licensed VFA service provider in Malta, most of them dropped out. So I would say that in terms of the, let's say, general funnel of applicants coming in at the doors of the MFSA, most of them are prepared, because most of the service providers guiding them in terms of the law firms or other professionals, they have been prepared for the past 2 years, and they're telling them straight away, these are the requirements. Are you ready to comply with these or not? If you're not, sorry, then maybe MICA is not for you. So we have a lot of applicants in terms of not just us, but generally for CASP licenses, mostly. There are some applicants as well for an AMI license in terms of the issuance of ARTs. Interestingly enough, there hasn't been a lot of uptake in terms of authorization as ART issuers. And I think maybe that boils down to perhaps the concept of ARTs not being entirely resonant with the concept of stablecoins in general, even though ARTs are stablecoins under MICA. And there's a lot of, I would say, promise for them, because they can be crafted differently than EMTs with a less rigorous licensing process or authorization process, since they don't need to be EMIs or banks. But generally, I would say that most of the applications are for CASPs. Obviously, there are some applications inbound for EMIs. Still to date, as far as I'm aware, there are no authorization procedures for ARTs ongoing. So that's by way of a bit of an overview in terms of the funnel, so to speak.
Great, thank you. Just a comment, we were in the past also talking to some NCAs, and there might be, like in Europe, globally, some interest for asset reference tokens, but I'm basically personally at the most curious about this type of stable coins when it comes to MICA.
And perhaps because Anya was also very much interested in the topic of stablecoins. Incidentally, it's also the topic I'm interested in the most. So, Paolo, I don't want to put any pressure on you, but perhaps we can have a separate session about stablecoins under MICA, because I think that would generate a lot of interest.
We had another one was not about stablecoin, was about tokens in MICA. So this is the second one about CASP. Of course, we could have another one just focused on stablecoins. So that'd be interesting. Yeah, Marina, please.
I mean, if we still have time, I just wanted to, because we're talking about crypto as a service providers, thinking about reverse solicitation. I think it's a very important topic when it comes to like an international audience, as we have here.
I really, sorry to cut you off. I wanted to maybe I was thinking to create a study group just dedicated to reverse solicitation, but not only in Europe, but just worldwide. I mean, really, what happens, and maybe inviting people from all different jurisdictions, not only Europe, maybe US, other major countries. What happens when some companies selling tokens into market without being established in that market and without having an authorization in the market? As far as I know, the only clear rule is in Europe with this reverse solicitation. As far as I know, there are not so clear rules in other jurisdictions. And I know that the SEC, but maybe Sarah can tell us about it, thinks that they can they have jurisdiction over every company that sells tokens into the US. Just selling tokens into the US, they think to have jurisdiction. But yeah, that would be a very interesting study group about just putting together people from different countries. Yeah,
maybe just the last comment on CASPs. This is on CASPs, so not reverse solicitation. I was talking to some researchers and also reading some articles. I think one of the very interesting part when it comes to CASPs compared to traditional finance institutions is that we have CASPs that do have or operate specific services that usually are not bundled within one institution or one organization. And that was also something that ESMA was looking a lot into. There were a lot of critiques that maybe, you know, we are not regulating CASPs as we should. Like the regulation is not as strict as it should, because some researchers were also going into the direction that there should not be like bundling or like, you know, few basically activities coming from one specific organization. And that's also very interesting because it was kind of an innovation. It's a new thing right now because of the technological aspect of how things developed in the past within CASPs, and again compared to traditional institutions, just as a thought.
Yeah, I think you hit the hammer on the nail there. If I just think about these centralized exchanges, liquidity providers, and automated market makers, here we go, where you have these different roles and difficulty to, kind of keep them apart. You know, who is actually offeror, who is provider, and what are the prerequisites, requirements for falling under this definition. I think that's very relevant.
So I don't know if there are other comments, ideas, or maybe we can. No.
I need to jump off because I have another call.
Okay. Thank you for coming, Jonathan.
Thank you very much.
Yeah, but by the way, I think we can close it now. This session, I think. So thank you everyone for being here, and as LexDAO, we are very happy to have created, organized this study group, and please be tuned with our next study groups. Thank you. No.
Ciao.
Ciao. Ciao. Bye.
Bye. Thank you.
Bye, guys. Bye.
Ciao. Thank you, everybody.